Okay, let's get started. Hello and welcome. Thank you for joining us today at Buildings New York Unlocked. This is the fourth in our series for 2022. My name is Christina Wilkes and I'm with the Buildings New York team. Before we start with today's content, I would like to remind you all to mark your calendars for our in-person Buildings New York show that's coming up on September 14th and 15th, again at Pier 36 on the Lower East Side of Manhattan. That show is in its 37th year and it serves building owners, property managers, facility staff from the New York City area, as well as the broader tri-state area. At Buildings New York, you'll be able to access resources to help you operate more efficiently by learning more about the latest trends and issues, accessing available products and services, and networking with others in the industry. Registration will be opening shortly, and you can learn more at www.buildingsny.com. And now on to today's discussion. We are pleased to share expert insights brought to you by the Habitat Group today. And today's topic will be requests for assistance animals and dealing with tenants' nuisance animals. The Habitat Group produces reliable resources that address the specialized concerns of today's property professionals. Their publications are resources for commercial and residential real estate professionals alike, as well as their attorneys. And they provide plain English guidance on management, lease, and regulatory compliance matters, and advice and practical tools on a wide range of operational issues encountered by property owners, managers, and leasing agents. To host our program today, please welcome Heather Stone, Executive Editor of the Habitat Group. And with that, I will turn it over to Heather.
Thank you very much, Christina, and I'd like to thank Buildings New York for inviting us to present today. Before I introduce our speaker, I'd just like to let everyone know that we have a lot of slides. We'll be going pretty quickly, I think, through them, but you will be receiving a copy of the presentation of the slides within a day or two of the webinar. We'll send those out. And then a few days after that, we'll also send you a link to the video of today's presentation. We will have a Q&A at the end of the presentation. We have a few minutes for that, and I'm sure we'll get a lot of questions and we'll do our best to get through them. Yes, we will move along quickly. So without further ado, I'd like to introduce our speaker today, Michael Littman. He's partner at Sidrane Schwartz-Sidrane, Perinbasekar and Littman LLP in Rockville Center, New York. As the lead partner in the firm's transactional department, he handles closings for multifamily buildings as well as single-family residences. He is also an experienced litigator in housing court and Supreme Court and has handled a wide variety of DHCR cases that challenge owners in the daily pursuit of managing buildings in New York City. So I will turn it over now to Michael. Thank you very much for being here today.
Thank you for the introduction. Hello to everyone. Thank you to Heather and the Habitat Group, as well as Buildings NY for having me and hosting this webinar. And with that, we'll get right into it. So the first topic concerns pets. Are you allowed to have a no pet clause in your lease? Absolutely. It is legal, but it must be enforced strictly, and I'll get to that in a minute. The pet law may override a no pet clause in a lease, meaning even if you have a clause in your lease, and it's in most standard leases, there may be a waiver of that clause in your lease, and you may be forced or you waived your rights to enforce that section of your lease. And I put up a couple of examples of the no pet clause that would appear in the lease. That's on the next slide, Heather. Thank you. The first one is from the Real Estate Board of New York lease. It's pretty extensive. You could see it up there. It says what's prohibited. Dogs or animals of any kind may not be kept in an apartment unless it's expressly permitted in writing by an owner. And this Real Estate Board of New York lease provides that an owner has to give consent in order for a tenant to have have an animal in their apartment. And then below that is the 2019 Blumberg lease. And that provision is much shorter. It just says dogs, cats, or other pets are not allowed in the apartment or building. As I said, the New York City pet law may override a no pet clause in a lease. And the New York City pet law is found in the Housing Maintenance Code. It provides the rights and responsibilities of owners and tenants in relations to pets. It applies to renters living in buildings with 3 or more apartments, and to the owners of co-op apartments in all 5 boroughs of New York City. It's also important to know that it also applies to condo owners in Brooklyn, Queens, and Staten Island, but it doesn't apply to condo owners in Manhattan and the Bronx. It also does not apply to NYCHA housing. In the New York City pet law, the legislative intent is provided, and it states prohibitions against the harboring of household pets has led to widespread abuses by building owners or their agents who knowingly have a tenant that has a pet for an extended period of time, seek to evict the tenant and or his or her pet, often for reasons unrelated to the creation of a nuisance. So the legislative intent was to prohibit owners from seeking eviction cases against tenants because they have a pet. And it goes on to say that household pets are kept for reasons of safety and companionship. And under the housing emergency that exists in New York City, it's necessary to protect pet owners from retaliatory eviction. And that's why there is a New York City pet law. Now, a landlord, as I said earlier, can waive the right to enforce a no pet clause. And there's certain elements to be met. The tenant has to keep the pet open and notoriously. The landlord or its agent has to have known or should have known of the pet for 3 months or more. And the landlord does not commence a court proceeding to enforce the no pet clause. And I bolded the word commence, and I'll get to that in a little bit. It's important. If you are put on notice or if you learn that a tenant has a pet that is against the no pet policy in their lease or the rules of the building, you have to actually start the court proceeding within a 3-month period of time. Also, if the waiver applies for one pet, so if Miss Smith in apartment 1A has a dog and you come to realize that she had a dog and you do not do anything for a year, obviously you waived your right to start a proceeding and to try and have Miss Smith get rid of the dog. But she also has a cat. The waiver only applies to one pet. So it does not mean that there's a waiver for an additional pets or future pets. Obviously, if you're aware of all of the pets, it would be a waiver for everyone, or for every pet, I should say. Where a tenant in a multiple dwelling, openly and notoriously for a period of 3 months or more following taking possession of a unit, harbors or has harbored a household pet or pets, the harboring of which is not prohibited by the multiple dwelling law or the health codes of New York City or any applicable law, the owner or his or her agent has knowledge of this fact, and the owner fails within 3 months to commence a summary proceeding or action to enforce a lease, then the lease provision shall be waived. And that's what the law states. So simply keeping a pet open for 3 months is not enough. The landlord must have knowledge of the pet. In some cases, it's enough that the landlord should have known about the pet. And once you get to court, it's the tenant's burden to prove waiver. This would be an affirmative defense in response to a landlord's holdover proceeding, for example. In many pet law cases, the critical fact question is the date on which the landlord was put on notice of the presence of a dog or any pet in violation of the no pet clause in the apartment. Frequently, tenants have established notice by showing that building personnel frequently saw the tenant walking in and out of the building with the pet. Also, waiver of the no pet rule can be found even where the pet is not regularly taken outdoors. In a case in New York County that I came across, there was proof that various maintenance employees of the owner had seen the dog. The dog can be therefore deemed to have been kept openly and notoriously for purposes of the statute. So even if the owner does not himself or herself see the pet, but one of the owner's employees, that knowledge would be imputed to the owner. For the purposes of the 3-month waiver rule, as I said, notice to the building super, for example, of the presence of the pet is deemed notice to the landlord. This is true even if the superintendent in fact never reported the pet to the landlord, and even if the landlord had specifically set forth a policy that reporting the presence of pets in tenants' apartments was not part of the superintendent's responsibilities. So what I mean by that is that even if the super's role in being the super in the buildings does not include reporting back to you whether or not tenants have pets, that's not an argument for a landlord to make, because they would not win on that argument. If the super or any employee becomes aware, then it's the same thing as the owner being aware of that pet. However, there are some cases involving large buildings or developments where courts have made it more difficult for tenants to establish notice, holding that the landlord's personnel cannot reasonably be expected to track the coming and goings of every tenant in the complex. In one case that I found in, I think it was also in New York County, so in Manhattan, where the tenant's building had no doorman or resident superintendent, and the building itself was at the outer edge of the complex, and the tenant could reach the street directly from her building without proceeding through the rest of the complex. The court held that the tenant's activity of walking her dog was not enough to provide notice. The landlord did become aware of the problem once it investigated another tenant's complaint about a barking dog in the apartment. So long as, and the landlord brought a summary proceeding within 3 months from that date of the landlord becoming aware. Although the dog may have been in the apartment for over that period of time, what's important is when the landlord actually became aware. In that circumstance, the landlord brought a case within 3 months, and the landlord was deemed not to have waived the no pet clause in the lease. In a recent Brooklyn case that I also found, there was testimony that from the tenant that the dog in question was walked through the public hallway and outside the building twice daily. The building employees in that case had seen the dog during several visits to the apartment for the purposes of performing repairs. There were conversations between members of the tenant's family and the building super regarding the dog. In that case, the court found that the tenant had established that a dog was open and notoriously harbored for a period well exceeding 3 months. And therefore, in that case, the landlord waived the right to enforce the no pet clause in their lease. I think I said this earlier, but it's important to note again, the prior waiver will not prevent the landlord from objecting to the presence of a replacement pet. So there could be waiver of multiple pets in an apartment, or if Miss Smith, in my example before, has one dog and the dog passes away and she gets a replacement dog after, the waiver did not, the landlord did not automatically waive their right to enforce the no pet clause for this new dog. So in that scenario, as soon as the owner would become aware of the new pet, the owner would have to commence a proceeding within that 3-month period of time. What do you do if a tenant is violating the no pet clause in their lease? The first thing to do is to take notes of the date that the pet was first observed or that you were put on notice of the pet. And of course, contact your attorney. Your attorney most likely is going to initially draft a 10-day notice to cure. I put an example on the PowerPoint of a 10-day notice to cure language, and it says tenant has violated the terms and conditions of the lease, section so-and-so, by harboring 2 dogs in the subject premises without the express written permission of the landlord. The notice also says when the dog was first observed by the landlord, and that's important to have in there. And then obviously the notice to cure will also have a date by which the tenant needs to cure the condition. In this case, they would have to not have the dogs in the apartment anymore. If they do not remove the dogs or whatever animal it is, then the next step would be to have a 10-day notice of termination served and drafted. This would notify the tenant that their tenancy was being terminated because they didn't cure the conditions. And thereafter, a holdover petition would be drafted and filed and served with the court. In order to avoid the 3-month waiver rule, the landlord must actually commence a holdover petition within 3 months after acquiring knowledge of the pet. It's not enough just to serve the notice to cure within the 3-month period. And that's important. So there have been times where one of my clients has called me, just under the 3-month period of time and says, serve the notice, we only have a few days left. At that point, it's too late. You have to commence the action within the 3-month period of time. So if you become aware of a pet and it's in violation of the building rules or in violation of the lease, you need to contact your attorneys immediately. What situations would waiver not apply? Waiver shall not apply where the pet causes damage to the subject premises, creates a nuisance, or the pet interferes substantially with the health, safety, or welfare of other tenants or occupants in the building. So this would be an exception to waiver, even if you knew of the pet for more than 3 months. Obviously, the pet cannot be a nuisance, and it can't endanger the safety of other residents or occupants in the building. If it does, then you could bring a case against that tenant for that purpose. Also, waiver does not apply if the particular animal is not allowed to be kept as a pet. The waiver provision, as I stated earlier, does not come into play when there are pet-related nuisances, which would include loud barking, aggressive behavior, foul odors, urinating or defecating in public areas of the building, having more animals than the person could care for. In each of these situations, it would be an exception to the waiver rule. It's also important to point out that the pet law applies to all pets. Obviously, most common are dogs. However, it's for all pets. Cats and other small pets are unlikely to be taken throughout the building on a regular basis, and therefore are much less likely to be seen by a landlord or its agents. Typically, these types of animals are only seen if there's repairs or maintenance that take place inside the apartment. Therefore, I think it's important, and I always remind my clients that you should instruct all your employees what to look for. For example, signs of pets, litter boxes, food, water bowls, pet gates, cages, etc. And if they see any of that, they should immediately notify either management or the landlord, because that is when the 3-month period of time starts. Remember, if your employees see it, it's the same thing as if the owner of the building sees it with their own eyes. New York City, on their 311 website, details a whole list of pets that can and cannot be kept as pets in New York City. Obviously, not all of these would be allowed to be kept in an apartment, but you could see the list. It's up on your screen. Cats, dogs, rabbits, hamsters, birds, turtles, and I thought the next list was funny. These are all the animals that may not be kept as pets in New York City. And you can see the list is quite exhaustive. I don't think it's shocking to anyone that you can't keep a lion or a shark as a pet in New York City, but that's the entire list that New York City lays out. And that concludes the first portion of today's webinar. I'm going to move on to the governing laws in regards to assistance animals. And I think Heather addressed this in the beginning, but if there's any questions, please feel free to hold on to them at the end, and I will try to get to everyone's questions at that point. So the governing laws in relation to assistance animals. First and foremost are the federal laws. I'm sure everyone has heard of the American with Disabilities Act of 1990, and also the Fair Housing Act of 1988. The ADA largely overlaps with the Fair Housing Act. The Fair Housing Act specifically governs housing and provides the federal standards. There's also the New York State law, the New York State Human Rights Law, and that governs New York State. It's enforced by the New York Division of Human Rights, and it governs all discrimination claims, including those based on disability, excuse me. We also have the city laws. So the New York City Human Rights Law. This governs the city of New York and is enforced by the New York City Commission on Human Rights. Just like the state law, the city law governs all discrimination claims, including those based on disability. Who must obey these laws? For our discussion purposes, everyone who provides housing or lending for housing, including landlords, real estate operators, brokers, agents, mortgage lenders, banks, apartment managers, rental agents, builders, developers, homeowners advertising and selling their home, janitors, superintendents, condo and townhome owner associations. In general, a tenant can bring a private cause of action either in state or federal court, or they can seek relief through federal, state, or local agencies. And that's if they believe they've been discriminated against. The laws are found to not be inconsistent with each other, nor do they preempt each other often. Often the New York City law is more stringent than the state or federal law. What is a disability and who is covered? A disability under all applicable laws can be physical, mental, or psychological. Under the federal law, it defines a handicap as a physical or mental impairment which substantially limits one or more of a person's major life functions, such as walking, talking, seeing, speaking, working, etc. Under the New York State and city laws, the definition of disability is much more broader. It does not require an impairment of a major life function. Both laws, New York State and New York City, provide much more comprehensive coverage than the federal law, the Fair Housing Act, and are intended to cover any physical, mental, or medical, psychological impairments that prevent normal functioning. All of the laws that I've spoken about cover persons who are tenants or occupants or intend to occupy a unit. For example, a applicant for an apartment. There's a long list of examples of physical disabilities, and that includes orthopedic conditions, visual impairments, speech and hearing impairments, and so forth. There's also obviously a long list of mental or psychological disabilities. These include bipolar disorder, schizophrenia, autism, general anxiety. And obviously it's important to keep in mind individuals may have a combination of impairments. They may not just have one. I'm sure you've all heard of the term reasonable accommodation. In terms of housing, what is it? It's a change in rules, policies, practices, or services necessary to give people with disabilities an equal opportunity to use and enjoy their homes. For the purposes of this seminar, an example of a reasonable accommodation would be allowing a pet in a no pet building. So if you have a tenant who lives in a building and the building's rules include that there's no pets, their lease says that they're not allowed to have any pets. However, they come to you and they say, due to my disability, I'd like you to make a reasonable accommodation and allow me to keep my pet or assistance animal. So what happens in that scenario? How do you respond to a tenant's request for an accommodation? There's 4 things you should do. The first is you should document the receipt of your request, whether it be in writing or orally. It's important to note when the request was made. Owners are obligated to take requests seriously, and failure to respond in a timely manner can be found a constructive denial of the request. You also need to have cooperative dialogue with the tenant. After receiving a request, an owner must start a cooperative dialogue with the tenant to address any issues and get information. The requirement to engage in dialogue is required by law. So the worst you could do is to get a request from a tenant and to not respond and to avoid them. Absolutely, you need to have some sort of back and forth with them and talk to them. The next thing you need to do is evaluate the claim. Owners must look at a tenant's request and requirements under the law to determine if the tenant's request is reasonable. Keep in mind, any request does not mean that it's a reasonable request. It has to be reasonable. You also have to give a written response. So after evaluating the claim, you should provide a written response to the tenant. It's advisable that early in the process, you send a letter indicating that you are evaluating the claim as well. And that's for the purpose of the tenant not thinking that you're ignoring them or that you're not responding. You want to try and work something out with the tenant. You don't want them to think that you're ignoring it or denying them and have them file some sort of claim against you. Evaluation of a claim for an accommodation. And I'm going to focus on New York City claims. I don't know how relevant it is to our discussion, but in New York City, an owner must pay for an accommodation. And what I mean by that is there's examples of certain accommodations that you could provide to someone who has a disability, such as giving a reserved parking spot to a disabled person or providing porter services, things like that an owner would pay for. But that's a little outside of the scope of this webinar. So what do you do if a tenant makes a reasonable accommodation request? You need to investigate the disability. So an owner is permitted to ask for information regarding the disability. The tenant can prove a disability through a doctor's note or limited medical records. The investigation is not an excuse to pry into a full medical history. If the condition is something that's obvious such as the tenant is blind, excuse me, or in a wheelchair due to a permanent condition, the request for information should not be made. Under federal, state, and local laws, they all provide that the owner is responsible for paying, as I said earlier. And in New York City, the issue is whether the change is an undue burden. In general, rule changes are not undue burdens. Again, this is a change in the rules, policy, practices, or services of a building. For our purpose, allowing a guide dog or emotional support dogs contrary to buildings' no pet policy would be an example of a change in rules and a reasonable accommodation. The object here is not to give a disabled tenant an advantage, but rather equal enjoyment of the premises with others. Any accommodation should not cause significant damage to others. Quickly, I'm going to go through litigation claims in court or before agencies. So if a tenant's not satisfied with the landlord's response, they can sue you in state, federal court, or before administrative agencies. Simply denying a reasonable accommodation is considered discrimination under the law. There's a list of the different venues that a tenant can sue you for. In each of them, there's different relief that can be afforded. So in federal court, just like the other venues, there could be compensatory damages, which means money for actual losses that have occurred, emotional distress damages, punitive damages for improper conduct. Punitive damages are for damages to punish the individual, and attorney fees. In federal court, they could also require you to implement the reasonable accommodation, and tenants could also get relief ordering you to fulfill the accommodation pending the resolution of the action. In New York State court, it's similar to federal court, the relief that can be granted in housing court. So if you sue a tenant for a non-payment or for a holdover, these types of claims are generally in the context of a counterclaim or a defense where a tenant requests a reasonable accommodation. Again, housing court could direct an owner to provide a reasonable accommodation, but housing court does not have the jurisdiction to enforce damage claims. A tenant could also file their claim with the Department of Housing and Urban Development. When a tenant files a complaint before HUD, they investigate the claim to determine if there's probable cause. If there's not, then it would be dropped. If they did find that there was discrimination, they could issue an order to stop the conduct or provide a reasonable accommodation. There's damages for actual damages, emotional distress, expenses. There could also be civil penalties, and those are up on the screen. 2 or more within a 7-year period of time could be $105,000. So these penalties are not to be taken lightly, and you need to take all of your tenants' requests seriously. Before the New York State Division of Human Rights, they investigate claims just like HUD. They can provide the same relief, and their penalties are a little higher in New York State. $50,000 for non-willful actions, or up to $100,000 for willful. And then last are New York City claims at the New York City Commission on Human Rights. The penalties there are $125,000 for non-willful actions and up to $250,000 for willful actions. They could also force you or force the owner or management to undergo training. They can also issue criminal penalties. Things to consider in terms of litigation. If an action is brought before any agency, you're subject to substantial fines. In all forums that I discuss, you're required to hand over documentation. And that's why I said you should keep notes of dates, times, conversations, etc. Depending on the claims and defenses that are raised, you may be required to provide financial information. So if the landlord was claiming that it's an undue financial burden on him or himself to allow a reasonable accommodation, the owner may be required to provide financial information to prove that. In New York City, it's the owner's burden to prove undue hardship. And you need to show that it would be impossible to do what's needed. Usually that's not the case with pets. Reasonable accommodation requests for pets can either be a service animal or emotional support animals. The Americans with Disabilities Act, so the ADA, defines service animals as dogs that have been individually trained to do work or perform tasks for an individual with a disability. Examples of such work or tasks include guiding people who are blind, alerting people who are deaf, pulling a wheelchair, alerting and protecting a person who's having a seizure, reminding a person with mental illness to take a prescribed medication, calming a person with PTSD. Service animals, they're working animals. They're not considered pets under the law. Service animals are exclusively dogs, and they've been trained to provide this service, and it must be directly related to the person's disability. Dogs whose sole function is to provide comfort or emotional support do not qualify as service animals under the Americans with Disabilities Act. Moving on to emotional support animals. An emotional support animal is a pet that provides disability relieving emotional support to an individual, but is not necessarily trained to do so. So that's very different from a service animal, right? A service animal is only a dog and it is trained. Vice versa, an emotional support animal does not necessarily need to be trained, and it could be any animal. And their primary role is to provide disabled owners with emotional comfort. Emotional support animals can be claimed by individuals with mental disorders. The most common claim that we've seen is anxiety. If a tenant is able to prove a disability and show that the animal is necessary to treat the disorder, then the tenant will be able to keep the pet regardless of a no pet clause in a lease. The New York City human rights law does not require the animal to be a dog or specifically be trained. The issue is exclusively whether it helps with the disability. Also, the pet should not be dangerous to others or otherwise a nuisance. Other situations where a landlord can deny an emotional support animal, yes. And let's go through those. The Federal Fair Housing Act, as part of a little background, bans discrimination in housing on the basis of race, color, religion, sex, national origin, familial status, and disability. As it applies to service animals for disabled residents, the Fair Housing Act states any person with a mental or physical disability cannot be turned away from housing with their service animal or emotional support animal. And this includes buildings and apartments that don't normally allow pets. Under the law, landlords are required to make reasonable accommodation for both service and emotional support animals. What's the difference between the two? I've already discussed that a little bit. And although emotional support animals and service animals have the same responsibilities, they do have differences. As I said, service dogs are not considered pets, Like all assistant dogs, a psychiatric service dog is individually trained to do work or perform tasks that mitigate their handler's disability, such as PTSD. The Americans with Disabilities Act requires 3 things for a dog to be a service dog. The person must have a life-limiting disability, which could be physical or mental. The dog must be trained to recognize and respond to the handler's disability by doing either work or tasks. And the dog must not cause a disruption in public. They must be housebroken and leashed, except when the dog needs to be off the leash to do their tasks. What do you do if a dog's service status is not obvious? You are not allowed to ask about a person's disability or require work or task performance or documentation of any kind, but you may only ask 2 questions to figure out whether the dog is a service dog. The 2 questions are, is the dog a service animal required because of a disability? And what work or task has the dog been trained to perform? Those are the only 2 questions you may ask. I think I mentioned service animals are not technically pets. Moving on to emotional support animals. I gave you the definition already, and it's up on the screen. A regular pet can be an emotional support animal, even if a mental health provider writes a letter saying that the owner has a mental health condition or disability that needs the dog's help for his or her emotional support. While the ADA does not grant owners of emotional support animals the right to be accompanied by these animals, the Fair Housing Act does. And so that's why owners have to provide a reasonable accommodation in that circumstance. And just as landlords must allow a visually impaired tenant to keep a guide dog, a landlord may be required to allow a psychiatrically disabled tenant to keep an emotional support animal. Under the Fair Housing Act, a landlord has the right to ask for proper documentation for emotional support animal to prove the tenant is in need of an emotional support animal. And this document is in the form of a letter from a mental health professional. In addition, the letter must be signed and printed using the mental health professional's letterhead. Can't just simply be, a handwritten note on a tissue. And there's very specific rules set in place by the Fair Housing Act when it comes to having an emotional support animal. A landlord or property owner is not allowed to make a tenant pay any extra rent or deposit for having an emotional support animal, cannot ask a tenant about their disability, cannot require the tenant to register the animal, cannot require the animal to have any specific training, and you cannot refuse to house the tenant because your insurance does not cover emotional support animals. However, reasonable accommodation requests can be denied if it imposes an undue financial or administrative burden on the landlord. An example is the tenant could be denied housing if the emotional support animal is extremely large, such as the horse. When a landlord does refuse a request for a reasonable accommodation because it's not reasonable, the landlord should discuss with the tenant whether there's an alternative accommodation that would effectively address the tenant's disability without imposing an undue financial and administrative burden. A landlord should not assume an assistance animal is not required based on visual appearances because many disabilities are not immediately apparent. Some examples include some assistance animals alert tenants with diabetes of low blood sugar, or guarding a tenant with epilepsy from injury during a seizure, or helping someone calm down who has autism. Not everyone with a mental illness will qualify to have an emotional support animal. There's specific requirements that must be met. Number one, the person must have a disability. And the definition is the person has to substantially be limited in a major life activity, such as working, caring for themselves, performing manual tasks, walking, seeing, hearing. Simply having a diagnosed mental illness is not enough. If a tenant receives SSI or SSD benefits, then they probably meet the requirement of having a disability for our purposes, because they're not, or they've been found unable to work, which is one of the major life activities. This person must also be qualified to live in the housing accommodation. Third, the type of animal must be reasonable. So something important to remember is the right to have an emotional support animal is based on the theory that it's a reasonable accommodation that the landlord is making. And the landlord only has to agree if the request is reasonable. In New York City and New York State, a tenant cannot request permission to keep an animal that's illegal. So they can have an emotional support animal that's a shark, obviously. But there are a whole list of animals that they can have. The landlord must balance the landlord's interest with the tenant's interest. Therefore, a landlord may reasonably deny a request to keep an animal that could damage the property, is noisy, or might harm or frighten other tenants. In those situations, a landlord's interest in maintaining his property or her property in a safe manner would outweigh the tenant's interest in having the objectionable pet. Lastly, there must be a need for the animal in order to live in the housing accommodation. The tenant needs clinical proof that having the animal is necessary to improve their ability to function. The emotional support animal must help the person cope with the symptoms of their illness. The letter from the clinician must include the following information: how long the clinician has been treating the person, the tenant's diagnosis, that they have a disability that limits a major life activity, and that the person needs an emotional support animal in order to fully use and enjoy the apartment. Under the federal law, so under both the ADA and FHA, there's no breed restrictions. And what I mean by that is if a disabled individual has an emotional support animal or service dog that the landlord prohibits, such as a pit bull or a Rottweiler, you must still accommodate that tenant and their service dog regardless of dog breed. Obviously, there's exceptions if that particular animal is a nuisance, or that you could provide, or you could prove that it's dangerous to others. And with that, that concludes my presentation. I think I'm right on the dot with timing, and I'd like to open it up with questions. But before we do that, I forgot I included this. So, these are questions that I put up that my office frequently gets from landlords in relation to pets and reasonable accommodations. The first one is, what type of medical information or documentation can a landlord ask? You can ask for documentation that will confirm that the tenant's disabled and that the animal relieves the effects of those limitations. You can only ask for information that can be used to determine whether the accommodation request is necessary. It does not necessarily need to come from a tenant's physician. So a letter from a therapist can be enough. And the other frequently asked question I gave for today is what types of animals can qualify as assistance animals. So as long as they're a legal pet allowed in New York City or New York State, then any type of animal can qualify, but they need to be reasonable. Thank you.
Okay, thank you, Michael. We've got some questions and I'd like to jump right in here. Is a tenant able to have more than one assistance animal?
Sure, thank you for the question. If a tenant needs more than one animal to alleviate their symptoms associated with the disability, and they could provide the proper documentation that I went through, and each assistance animal eases the symptoms of a particular disability, then yes, they can have more than one assistance animal.
Okay, can a landlord treat a request for an assistance animal differently depending on whether the tenant making the request is a longtime tenant or a new tenant?
So no. So a tenant that's been there for a day versus 30 years has to be treated the same way. They have to provide documentation, as I went through, showing that they need an assistance animal, and the lack of any past requests cannot be used against them as well.
Okay, can a landlord deny a tenant's request for an assistance animal based on the allergies of other tenants?
So the answer is no. However, a landlord could perhaps move that tenant or the other tenant to another unit in the building to lessen the exposure if someone is allergic to that pet, or if it is a health risk for others to be exposed to that animal.
Okay, can a landlord withhold a security deposit for damage caused by the assistance animal?
So the answer to that is yes, but only if that same penalty would be imposed to a tenant who does not have an assistance animal for the same type of damage.
Okay, and someone asked about requiring the assistance animal to be licensed in the city, have vaccination requirements met. Is that reasonable to require proof of that?
So for a service animal, they're going to be trained and licensed to do their tasks, but for an emotional support animal, no. You can't require that.
Okay, somebody asked, does this apply to private housing in which the landlord does or does not live there?
So no, unless the private housing contains 4 or more units. So I assume the question is regarding like a private house where the owner does not live there. So this does not apply.
Okay, and are assistance animals required to be allowed in common areas such as a lounge or roof deck, or emotional support animals?
Yes,
Okay.
as long as it's reasonable. So obviously if someone has an assistance animal that, would frighten little children and they're going to bring it to the play area, obviously that's not reasonable.
Right. Okay. What if a tenant says their guest has an emotional support animal for a short visit or an overnight stay? How does that work?
I mean, it's obviously a case-by-case basis. If it's a one-night stay, I assume you're not probably finding out about it in advance anyway. You're not, if someone had a specific example and they want to ask me after, feel free. if someone was staying with you for many days or many weeks and they have a pet that's in violation of the no pet clause, then they're not allowed to do that. But the tenant is not keeping the pet in the apartment. It's really a case-by-case basis and what the building rules are. If it's a service animal, obviously, they would be required to allow that animal in. An emotional support animal is a little different of a situation.
Right. What if your building's insurance, the terms are you can't allow Rottweilers or pit bulls, and a tenant requests an emotional support animal that's a pit bull? Can the landlord deny that request because it would be an undue financial burden that would go against their insurance? How would you handle that situation?
So again, case-by-case basis, they could try. But as I said, just because it's a specific breed or because the landlord's insurance would not permit it, that's not an automatic right to reject the request. Not every pit bull is the same pit bull. Some are bred to fight. Other pit bulls, can be the nicest, sweetest dog. So it really is a case-by-case basis. But just by saying that your insurance doesn't allow it, that's not an automatic no to the request.
Okay. Okay. Can we ask for proof that the animal is an emotional support animal? I think that you've already covered this a little bit. One thing that I'd like to mention, because we've had readers ask us about this, is that sometimes tenants give certificates that they've gotten off the internet saying this is a certified. How do you respond to somebody who?
So I dealt with that personally also. We had a landlord who had a dog that he claimed was an emotional support animal, and he provided some certificate from it was like www.emotionalsupportanimal.com, and he put the dog Sparky as the dog on there. It doesn't matter. It's not required. They don't need to be licensed or trained at all. There's no requirement for that. There is a requirement that they provide a letter from their clinician stating that they need that specific animal as an emotional support animal. So that's the requirement, but there's no requirement that that they provide any like city sign certificate or anything like that.
Okay, somebody asks, I was once sued for not allowing an emotional support animal in the building swimming pool. Has the law changed?
I don't think the law has changed, although I don't know when you were sued. So you could reach out to me, but the same holds. If it's reasonable and this person needs it to function, the goal behind the law is that these individuals should be able to access all of the amenities of the building just like every other tenant. And that's why I assume they were allowed to have their emotional support animal at the pool. Obviously if it wasn't hygienic or dangerous, then there's exceptions to that. But that sounds like a very specific question, which I'm happy to answer more after.
Okay, I think we have time for one more question. If there are 3 people in the household and all require a support animal, must the landlord approve all 3 pets? Animals.
Simple. The simple answer is yes. So one individual could have, a few different service animals, just like 3 individual tenants or roommates, they can each have their own. But it needs to be legitimate, and they need to prove it to you.
Okay, well, thank you very much, Michael. And thank you, Christina, for letting us present today's webinar. Thank you all for attending. And again, we will send you a copy of the slides in a day or two, as well as a link to the recording a few days after that. So thank you everyone for attending.
Thank you.
Thank you, everyone. Thank you, Michael. Thank you, Heather.